Hello and welcome to Employment Hour in 30. If you're just joining us for the first time or if you're coming back, good to have you back. Come on in. Water's warm. John Scholes here, Lior Samfiru. Right off the top, a way to contact 1-855-821-5900. That will put you in touch with Lior's crew. And you also have employmenthourtv.ca, which is nice, a way you can source our radio shows, which we'll talk a little more in depth in a few minutes. But we talk about employment law here, workplace rights, things that affect you. Could be 5 days a week, could be up to 8 hours a day or more. So this is important stuff we talk about every week here on the show. And we like to start, Lior, with what you call the week that was, stuff that's been happening in your office and you want to talk about on the show, right?
Yeah, I've had a lot of people that I've spoken with interesting matters. We're going to bring some of those up here as well because there's important lessons to be learned. And if you haven't watched our show before, we're solving workplace problems. We solve workplace problems on the show. We solve workplace problems on our radio show. And of course, I solve workplace problems in my office with my team. So by all means, call me, email me. There's no bad questions. There's no situations that cannot be solved. There's no situations that cannot be improved. So if you have a workplace problem, you want to know what your legal rights are, if you've always wondered, stay tuned here this week and every week. We'll talk about some very, very important things. And the week that was, this is where I talk about a case that came across my desk over the past few days, and I'm bringing it up only because there's important lessons to be learned for everyone watching. So this case involved a gentleman who had worked for a company as a driver. He was driving, making deliveries within town for a number of years. And he got paid a salary. But unfortunately for him, he was required to work some crazy, crazy hours, oftentimes as much as 60 and even more than 60 hours per week. Now, he got a salary and he asked his employer, well, what about overtime? Why don't I get any overtime here? Because I'm working 60 plus hours a week. They said, well, no, you are a salaried employee. And because you're not an hourly employee, you don't get overtime. It didn't seem right to him. It wasn't right. And that's why he called me. And he wanted to know, is this right and what can I do about it? So let's be very, very clear. Overtime is paid to people on salary. It doesn't matter if you're salary or hourly. You get paid overtime. You get paid overtime for hours worked over 44 hours a week. So if you work 50 hours in a week, you get 6 hours of overtime pay. Now, the way it's calculated for people that are on salary is whatever weekly salary you earn is good for only up to 44 hours a week. So you take your weekly salary divided by 44, that gets you an hourly rate. 1.5 times, that's your overtime rate. So yes, he gets overtime. The fact that they didn't pay it to him means he can actually go back 2 years. Okay, he can go back 2 years and recover overtime that's owed to him. And beyond that, he could, if he chose, not only can he go back 2 years, he could treat his employment as being constructively dismissed. His employer is not paying him what he's owed. That's a breach of the terms of employment. He could potentially leave with severance. So what I want everyone to understand is overtime. You get paid overtime if you work more than 44 hours a week.
I guess if you're in the situation where it starts to become a regular thing, where they're getting you to work overtime all the time, you should probably keep a log.
Yes, and that was one of the concerns, is how do I prove my hours of work? So if your employer doesn't have a logging system, a punch card, some other system to log your hours, log your own hours. Have some sort of a journal, a spreadsheet, whatever it is. You don't have to use the company's resources. Have a little notebook on your car dash where you put in, I started at 8 o'clock and I finished at 7 o'clock, whatever it is. Even though you created it, it's still fine, it's still credible, it's still useful. You don't want to get into a dispute with your employer where he says you didn't work overtime, you say you did. Always, always log your hours.
1-855-821-5900. That is the number to call anytime. Write it down, keep it with you. That will put you in touch with Lior and the rest of the crew. EmploymentHourTV.ca is a great website as well. We've been doing a radio show, weekly radio show, several times a week for over half a decade now. And during that radio show, of course, people call in. They have questions. They want to know stuff. We get the phone calls. We like to play them back here on Employment Hour at 30. So I'll get to one, Lior, and I know you want to comment on it.
I worked for the company for 22 years, and I got 2 accidents there, and now I cannot work. I'm on disability right now, and they were paying me the benefits for almost 2 years, and after 2 years, they changed the human resource manager, and she cut my benefits off. Where I stand with that.
Good call.
Very good call. So when we're talking about benefits, what I believe she's talking about is, the health, prescription, dental benefits, those types of benefits. Now, if you go off on a medical leave, your employer actually is not required to continue your benefits. So if you're going to be off, let's say for a month or 6 months or 2 years, your employer is not required to continue your benefits during that time. But If they do continue them, if they decide to continue them, they can't then discontinue. They can't then cut them off. So in this situation, her employer continued her benefits for 2 years, and now they're saying, we don't want to do it anymore. Now they're saying, we want to cut you off. They cannot do that. 2 years ago, they didn't have to continue, but they did. So what does this mean? This means that the fact that they've cut her off benefits may mean that she's been constructively dismissed, or that she has the right to treat that as a constructive dismissal and leave and get them to pay her severance as well. So I want everyone to understand, employers and employees, if an employee goes off on a medical leave, if they're not working anymore, you're not technically required to continue their benefit coverage. If you decide to do that, good on you, great. But then you can't cut them off, unless, of course, you tell them in advance, I'm only going to continue your benefits for 6 months. Be aware of that. In which case, that's fine. But if you continue benefits and then unilaterally decide to cut them off, that is not something you're allowed to do.
Questions or confused about this, call us or call Lior anytime, 1-855-821-5900, help@employmentlawyer.ca as well. Another phone call. I think we got time for one, so we'll get to another phone call from our radio show.
I was teaching at my last school for 8 years. It's a private school. I got my contract renewed as per usual. And then the day after the students graduated from school, I was hauled into the office and told they had decided to take the science department in a different direction and were thereby terminating my contract. I got 8 weeks termination package. And so here I am, 45 years old, almost finished my doctorate. There's nobody that is going to hire me with all those credentials. I'm at the top of the pay scale.
Yeah, difficult situation. And I see this often, by the way, with schools, private schools oftentimes, which are non-unionized, and a teacher may be, so supposedly an unrenewed contract. So the school year ends, we're going to renew you for next year. If you keep getting renewed, if every year you keep getting renewed in the summer for the following year, your company can't, or your employer can't just say, well, this year we don't want to, because it becomes a term of employment. You become a regular employee. So if your employer says, we don't want you there, well, they have to pay you severance. They can't just say the contract ended. So yeah, can the employer let her go even though she's done nothing wrong because they've changed directions? Yes, they can. Absolutely. Legally, your employer can let you go. But severance has to be paid. Now, she got paid 8 weeks severance. That's not even close to being right. So before I tell you how much she's owed, let's take that information and let's plug that into our very handy tool, the severancepaycalculator.com website, so that everyone can see how they could find out what this person is owed. So she's a teacher, 8 years of service at the age of 45. She was offered 8 weeks pay. Severance Calculator correctly says that she gets more than a year's pay. 12 to 14 months pay. So she was underpaid by almost a year of pay, John, a year of pay. So she's not going to just have 8 weeks to find a job. She could potentially have as much as 12 or 14 months to find another job. Much easier to find a job in a year than it is in 8 weeks. So she's been wrongfully dismissed. And the reason I brought this up as an example here is not because this is a unique case. There's actually nothing unique about the situation. Most people, when they call me because they lost their job, are in the same boat. What they're actually owed is 4, 5, 10 times more than what they've been offered. So she's been wrongfully dismissed. I would connect with her, help her, and get it resolved.
As far as contract workers are concerned, whether it's her or anybody else watching this show, what's the threshold as far as contracts being renewed till you're basically an employee?
So if you are a contract that keeps getting renewed, maybe you were on a 6-month contract that got renewed. Usually once we're into the 3rd renewal, then you become, in the eyes of the law, a regular employee. Why? Because after the 3rd renewal, you're not really going to expect your contract to end. You're going to assume it's going to continue getting renewed because you have this history there. So if the contracts kind of get renewed almost automatically and it happens a few times, the law may consider you no longer to be on contract, even though you signed a piece of paper. The law may consider you to be a regular employee, and that's very important if you lose that job, because now you should be getting severance as a regular employee, not as a contract employee.
Contact simple, by the way. Keep giving it throughout the show, 1-855-821-5900. It is simply employmenthourtv.ca, the website to check out more. We always like to get to a topic each week and dig a little deeper on it. I give you some talking points, you expand on it. This one, I mean, it couldn't be more appropriate with the workplace environment now all over that is, and that is workplace harassment, how to handle it.
Yeah, probably one of the more common things that I have to deal with these days is workplace harassment, situation where someone is mistreated at work. These things come to the forefront now. A few years ago, people weren't talking about these things. It's not that there wasn't workplace harassment. People weren't aware that that is a thing. Now that people are talking about it, you can read in the paper, online about these incidents, people understand, well, wait a second, that is not right. And it isn't right. So what we want to talk about in the next few minutes here is what is workplace harassment, what to do if you're a victim of harassment, and how to get yourself out of that bad situation.
All right, we'll start there then. Legally, what is workplace harassment? Give me some examples.
So workplace harassment is actually a broad term and has a broad definition. Workplace harassment is any type of conduct that is unwelcome or reasonably would be considered to be unwelcome. So if you're subject to conduct by someone else in the workplace, a boss, a coworker, whatever it is, that reasonably would be considered unwelcome and inappropriate, that is workplace harassment. Now, it could be many, many things. It could be a boss that talks down to you or uses profanity. It could be someone that makes fun of you in the workplace. It could be being excluded from meetings and not being given the information you need to do a good job. It could be being set up for failure. All this type of behavior that's unwelcome, that if someone were to look at it from the outside and say, that is not right, that type of behavior is inappropriate, is workplace harassment, and it oftentimes results in a poisoned work environment, an environment that makes it difficult to continue working, an environment that's unhealthy. So if you're in that situation, then yeah, you are a victim of workplace harassment.
Talking about workplace harassment, how to handle it, 1-855-821-5900 is the number. This sounds familiar to you, or any other case you want to call Lior on, that'd be just as well. Second point is there an obligation by the employer to stop it before it gets started or while it's underway, and what's the obligation?
Yeah, employers now have proactive obligations to prevent workplace harassment and do whatever they can to prevent that harassment. That may mean having policies in place, and employers have to now have workplace harassment policies that talk about what is appropriate behavior, what is inappropriate behavior, what measures are available to an employee that's a victim of harassment, who do they go to, what the company is going to do to combat harassment. And by having a policy, just having a policy is not enough.
No.
So if you're going to have a policy, you need to make sure that that policy is distributed to employees, that it's communicated, that people know what it means, what is right, what is wrong. Just having a policy and putting it in a drawer and forgetting about it doesn't do anything. So, and beyond that, if an employer is aware that someone is a victim of harassment, even though no one told them, they saw something, they observed, they can't just turn a blind eye. They can't just say, well, no one said anything to me, so I'm going to forget about it. You have to take measures to fix that problem. You have to investigate. It's a very serious obligation. Gone are the days where employers can say, boys will be boys, they'll deal with it, it's their problem. It is now the employer's problem.
Well, you mentioned being a victim of it, so if an employee or an individual is a victim of harassment, what's the next step for them?
So the first thing I would tell an employee that's a victim of harassment is, let's see if we can get this problem fixed, because the employer has an obligation to fix it. So let's give the employer that possibility. Let's give him the opportunity to fix that problem. So what do? Well, you go speak to someone. Maybe it's the human resource manager. Maybe it's a boss, an owner, someone in a position of authority, and tell them what happened. By the way, you want to do that in writing. So there's a record of what you said and what you did. Give them the opportunity to fix them. Tell them what happened. Tell them as much information as possible, events, dates, who was involved, and let them put the ball in their court to fix it. Legally, what they'd have to do is to investigate and take measures to repair that problem, but they can't do that if you don't give them the opportunity to do that.
I'm thinking that some of our viewers are thinking, yeah, you know what, I've been in this situation, or I've known guys or ladies in this situation. When you become the squeaky wheel, there can be repercussions. You can get punished for it. You're the workplace pariah. What do you think about that?
Yeah, the reality is the law makes it very clear now, and this is fairly new developments in the law within the last 2 or 3 years or so, that an employee cannot be punished in any way for bringing up harassment allegations. And that is true even if the employer concludes that the harassment didn't happen, even if it concludes that what the employee was experiencing does not rise to the level of harassment. The fact that the employee brought up those harassment obligations means that the employee cannot be punished, penalized, fired in any way for doing that. What does that mean? That means that every employee should feel empowered, should feel that they have the right to bring those allegations up, to have a right to have those allegations considered and investigated without the fear of repercussions. If your employer does, despite what I just said, does punish you, that is a reprisal. That's illegal. In some situations can even be a human rights violation. There's going to be significant consequences to an employer that doesn't do that punishes someone. So bottom line is, yes, you should feel comfortable that you have a right to go and complain about workplace harassment.
We're talking about workplace harassment, what to do about it. You want to reach out any other time, 1-855-821-5900. So an employer is hearing this, or maybe they have an employee come to them and they've been alerted to some harassment. First steps, how do they react to it?
First thing the employer has to do is investigate. Okay, they have to conduct a real thorough investigation of what actually happened. It's not one of those things that just because you complain, we're necessarily going to take your word for it. The employer has to investigate. Sometimes, depending on the situation and how complex it is, they may have to bring in an outside investigator that has expertise in these areas. Beyond that, the employer has to investigate. They have to talk to people. They have to find out what happened. And if they conclude that there was harassment, they have to take measures to fix it. Now, what do they do to fix it? Depends on the situation. It could be training the person that was harassing and making them understand what their obligations are. In some situations, it could be firing that person. Other situation may mean separating the two people that can't work together. But bottom line is, once you investigate and you conclude that something happened, there was conduct that was inconsistent with your workplace policies, you have to do something to fix it. You can't leave it to chance. You can't tell someone else to deal with it. You take measures to fix it. You eradicate the problem right away.
What does the employee do if the employer, number one, doesn't do anything about it when they're alerted about it? Number two, maybe the person you're supposed to report to is the one doing the harassment.
And that is a big situation. Oftentimes I get calls from people saying I've been a victim of workplace harassment, but it's the owner of the company. Right. So who am I going to complain to? Or HR doesn't do anything. They're afraid of the person that's harassing me. Or I've tried, nothing's happened. So once you've tried to deal with it internally, you've tried to deal with the problem internally and get it fixed, and it doesn't get fixed, you have to deal with it externally. At that point, you have to contact me, and I get involved. That may mean I get you out of there because it's a constructive dismissal. If you're a victim of workplace harassment, that's a breach of the terms of employment, which means you can get out of there with compensation so you don't suffer anymore. Sometimes I could simply give the company a bit of a kick in the pants so that they decide, okay, well, now that Lior is involved, we're going to pay close attention. Now we're going to do something about the harassment. But bottom line is we can deal with that externally. What I don't want anyone to do is ignore the problem. To say, well, I guess there's nothing I can do. I'll just have to continue and suffer. The problem with doing that is you're going to make the problem worse. You're going to probably feel worse. You may end up having to go on a medical leave of absence or a stress leave. I've seen hundreds of cases with people going on stress leave because of workplace harassment that wasn't properly dealt with. Well, deal with it internally. If you can't, or nothing's happened once you've tried, let me deal with it. Don't just suffer. Don't hope that it's going to go away. It's not going to go away if you don't do anything about it.
Still to come here, as promised, we'll get into some depth about the severance pay calculator and what to do if you're an old employee and you're let go by a new owner. That's a concern as well. All that is coming up, though. 1-855-821-5900 is the number to contact Lior anytime. Employment Hour in 30 continues. Don't go anywhere.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru. Anytime to contact 1-855-821-5900. As promised, we love this tool. It's been used by literally over 550,000 people. That is Severance Pay Calculator. And you can reach that, severancepaycalculator.com. Absolutely free.
Absolutely free. You couldn't pay for it if you tried. There's literally no place to put in your credit card number or other information. So what is this? Again, we have new viewers every single time we're on the air. So I want to emphasize this tool because it's helped so many people. And if you don't know about it, it can't help you. severancepaycalculator.com. Again, severancepaycalculator.com, a tool that I created to allow anyone and everyone to find out what is the right amount of severance that they're owed. The right amount, not their minimum entitlements, not this nonsense of a week per year of service or 2 weeks per year of service. So how do you find out the real amount? You go to severancepaycalculator.com, you answer the few questions there about your age, your position, and the length of your employment, and you'll find out in seconds whether you're owed 12-month severance, 24-month severance, or something else. Now, you don't have to just go there if you lost your job. Sometimes people get that spidey sense that something is coming down the pike, that they're going to be let go. Well, go to severancepaycalculator.com, have that information so that you're ready. Or maybe you're not getting a bad sense. You're just wondering, you're just curious. Or maybe your friend across the hall or your neighbor or your family member lost your job. Tell them to go to severancepaycalculator.com. It takes seconds and it's anonymous. You can do that on your smartphone, on your tablet, on your desktop, whatever it is. Check it out. And of course, if you want to talk to me after, there's a button there you can press, a little green button that you can contact me only if you want to. That information is valuable information. If you use it, you will not find out a year later that you were owed another $100,000 and now you can't do anything about it. So severancepaycalculator.com. Check it out now.
Make it a party game. Don't do that.
A drinking game.
Easy now. I want to get to an example that we got through email, by the way, about the calculator. That is reachable to you at help@employmentlawyer.ca. Email as follows. I worked in sales at the same family-run business for 32 years. Last week, one of the younger family members took over as manager. They fired me. Given that I'm 71, I wasn't shocked by this. They want to give me 12 weeks pay as a nice little retirement gift. Should I ask them to throw in a few extra weeks?
Well, there's a lot to unpack here. First of all, you cannot be let go because of your age. You cannot. That's illegal. You cannot do that. We don't have mandatory retirement, and I've personally spoken with dozens of people that work well into their 70s and beyond. I had a call this morning from someone that was 79 and was worried about losing his job. Good for him. Yeah. So he cannot be let go because of his age. As simple as that. So that's a human rights violation irrespective of severance. But if he is let go, of course he's owed severance. So you think that 12 weeks is a proper amount? That's not even close. So let's actually, rather than me just tell you what that is, let's go to severancepaycalculator.com, the tool that we've been talking about, and let's plug in this person's information and see what he's owed. 71 years of service. 71 years old. Holy cow.
32 years.
32 years of service. He was offered 12 weeks. Severance calculator, not surprising, says he's owed 24 months. 24 months of severance. So that's a difference of some, 21 months that he's owed more. I don't care what his compensation is, that's going to be a lot of money. So not only did he have his human rights violated if he's let go because of his age, he's owed another 21 months of severance. This is not that unusual. I've seen massive gaps that are in the hundreds of thousands of dollars sometimes. Don't let that happen to you. Don't accept less than what you're owed. Don't be confused or taken for a ride. severancepaycalculator.com.
Yeah, whether it's ignorance or they just don't want to pay it, make sure you go there first and check it out. Don't want to be shortchanged, right?
Why wouldn't anyone do that? Yeah. Grab your smartphone. We all have them now. You can do that in the boardroom while you're being terminated if you want. Right. Severancepaycalculator.com.
EmploymentHourTV.ca. That's a great resource to find where you can listen to our weekly radio shows. We are all over the radio several times during the week. On those shows, we take phone calls and we play them back on this show. Want to get to one right now.
I'm an employer, and I have a long-term employee who's at one location, and I want this person to move to another location. I'm not sure if she will go. If she doesn't, can it be construed as constructive dismissal?
Usually it's the other way around, coming from the employee.
Yeah, usually we are asked by employees that the employer wants to move. So here's the thing. If a move is a constructive dismissal, depends on the circumstances of the employee. So if you're moving offices, but that doesn't impact the employee that much, it's not a constructive dismissal. In some situations, the move may be better for the employee. It could actually decrease their commute to work, in which case, of course, it's not a constructive dismissal. So it's not the move that becomes a constructive dismissal, it's the impact of the move. So, of course, if this person would now have to drive an extra hour each way to work every single day, well, that's a big deal. That's a big change. That would be a constructive dismissal. So I would want to know more about how this is going to impact the employee. One of the ways to potentially get around that, potentially, is to give advance notice of this change. So employee, I'm telling you right now that in 6 months, 12 months, whatever it is, we're going to relocate. What does that do? That means that you may still have to pay severance, but the severance is going to be reduced by the amount of notice that you've provided. So yes, a relocation often results in a constructive dismissal if it impacts the person in a negative way.
Are you a part-time worker? Want to know how law affects you? We'll get to that after a short break. The number, 1-855-821-5900. We'll take a short break. That's coming up. And more of your phone calls from the radio show right here. Employment Hour in 30. Stick around.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. We have a weekly radio show, employmenthouratv.ca, to find where you can catch that radio show. On it, as mentioned earlier in the show, take a ton of phone calls, like to play them back here, and get you to comment on Lior. We'll get to that right now.
I'm an injured worker, and 3 years ago I had some procedures on my back. During that time that I was off for my back, I was told that I didn't meet the requirements for permanent disability or disability benefits anymore. So they cut my benefits off and told me I had to show up for work or I would be terminated from employment.
Oh, that's nice.
Yeah, that's very nice. Sure. Well, there's really 2 issues here to unpack and to discuss. Number one is not qualifying for disability. And I know you know a lot about this because you also host a radio show with my partner, Tumarkin, about disability issues.
Yep.
So let's be very clear on this. An insurance company often is going to try to cut you off disability before you're ready to come back to work, before your doctor says you're ready. And they're not supposed to do that, but they do that anyway. The good thing is this could be easily resolved. So number one, I would want to know why was this person actually cut off disability, because if the doctor says they cannot work and they feel that they cannot work, the insurance company shouldn't say, well, we disagree. We still want you to be cut off. We still want you to go back to work despite what your doctor says. So number one, right there, we may be able to deal with the insurance company. If that ever happens to you, if you're on disability and your insurance company is threatening to cut you off or they have cut you off, you really got to pick up the phone or send me an email. Let's talk. Let's get that resolved. Let's get you reinstated as soon as possible. Now, the second part of this is now the employer says, aha, we understand you're no longer on disability, therefore you have to come back to work or else. Right. While at the same time your doctor says, well, you can't work. No, it doesn't work that way. Forget about what the insurance company says. If you have a doctor that says you cannot work and you provide that note to your employer, that's it. Your employer can't penalize you for not working. Your employer can't make you can be off as long as you need to get better. If your employer gives you a hard time, that could be a human rights violation. That could be a termination or a constructive dismissal. You have a lot of rights. You really want to give me a call then.
That's 1-855-821-5900. Got a couple minutes to go. I want to get to another website you can use if you have questions about your employment as a boss, as an employee. Doesn't matter. Terminationquestions.com. And the one for today, Lior, is I'm still owed severance. Am I still owed severance when I've only been working part-time? My employer said no. I'm 31 and have been there for 10 years. Working in a grocery store.
That's a question that we got on the terminationquestions.com website. Very, very straightforward situation. You get severance if you're part-time, full-time, it doesn't matter. You get the same amount of severance. So this employer is wrong completely. So let's put this information quickly in the severancepaycalculator.com website to see what this person actually gets. A laborer working for 10 years at the age of 31, the severance calculator correctly assesses that the person is owed 8 to 10 months of severance. So it's not that she doesn't get severance, she gets 8 to 10 months.
At her part-time.
At her part-time rate, exactly. So you get severance full-time, part-time, it's all the same, and you can still use severancepaycalculator.com to find out what you're owed. Don't let anyone tell you that as a part-time employee, you don't get severance. That is nonsense.
Again, make that phone call first. We're going to take it from there for another week. That number is 1-855-821-5900. You'll want to find out where you can catch the radio show weekly, where we get our calls from. That is employmenthouratv.ca. And finally, email help@employmentlawyer.ca as well. Wonderful resources. No reason for you to be in the dark anymore with this show on TV and on radio. radio as well. Till next time, Employment Hour in 30. See you again.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.